Thanks, Austin, and thanks to everyone at the Hauenstein Center and George Mason for having me here, and thanks to all of you for coming out. One of the themes that I think we've heard today, for those of you who've been here all day, one of the themes that we've heard referenced repeatedly is that conservatives have been of mixed opinion about the presidency of George W. Bush. Now, Gleaves is going to talk more about this theme in just a minute, so I shouldn't spend too much time on it. But I just wanted to open by noting that it strikes me as a classic example of the leadership dilemma faced by presidents who are elected to fulfill the long-standing ambitions of a reigning regime. Like LBJ before him, Bush's accomplishments did not match these ambitions, and his failures and compromises sparked repeated charges of apostasy. Now, my topic is the president's judicial appointments, and it's fair to say, I think, that most conservatives have been more or less pleased with his major decisions in this regard, although even here, you'll remember he strayed from the path with his nomination of Harriet Miers, sparking a conservative rebellion that handed Bush the literally unprecedented fate of having a Supreme Court nominee defeated by the president's own party. Literally unprecedented, never happened before. Conservatives have been far happier with John Roberts and Samuel Alito, and with most of Bush's nominees for the lower federal courts as well. But when they look back on this era some years from now, I venture to predict that they'll see it as yet another example of promise unfulfilled. President Bush has moved the courts substantially rightward, but given the scope of Republican ambitions in this regard, a true remaking of the third branch, you'd have to say that they've fallen short. Now, this is in part because Democratic senators played hardball on this issue, using what powers they had, even in the minority, to block some of Bush's most conservative nominees, even at the height of his political authority. In part, also, of course, because President Obama and the expanded Democratic majority in the Senate may now be expected to push back pretty hard. For at least three reasons that I can think of. Obama's going to have a large number of judicial vacancies to fill right away. The Democratic Senate has moved slowly on Bush's nominees over the past 2 years, preserving a number of vacancies for the new president. There are a number of sitting Democratic judges who've been waiting around for a Democratic president before they announce their retirements. And Congress is considering and is likely to pass in the next year or two a bill that will expand the size of the federal judiciary in its current form, authorizing 16 new appellate judgeships, which Obama would then be authorized to fill. So taking all that together, by the end of his term, President Obama, I think, will have moved the federal courts back into a state of partisan balance. And if Obama serves a second term, the long-standing Republican judicial strategy may seem like a distant memory 8 years from now. Now, I don't have a lot of time, but what I wanted to do today to attempt to summarize Bush's legacy for the courts is to briefly illustrate his impact on the courts in two ways. First, very briefly, with some numbers, just summarizing the degree of personnel change on the federal courts that Bush has affected. And then second, with a rough assessment, this is hard to do quickly, but with a rough assessment of some of the key legal changes that have resulted from Bush's judicial appointments, and I'd like to do that by trying to summarize some of the key legal victories and defeats for each of the core elements of Bush's political coalition. So first, the numbers. As of this week, I just looked it up a couple days ago, approximately 38% of active federal judges were appointed by Bush. Now, if you combine that with the remaining judges on the bench appointed by his father and President Reagan, and there's still a couple, Nixon and Ford appointees on the bench, 59% of the federal bench is Republican appointees as of this week. Now, at the appellate level, federal circuit courts, where it's fair to say that most legal questions are settled because district courts hold trials that are applying the laws set by the appellate courts, and because the Supreme Court hears so few cases, right, that a good deal of federal legal questions are settled at the appellate level. The numbers there are 34 and 60%. Right? 34% of federal judges were appointed by our current president. 60% of them were appointed by Republican presidents. At the highest level at the Supreme Court, the numbers are 22 and 78%. Right? Bush has 2 of the 9 appointees on the court, and 7 of the 9 were appointed by Republican presidents. But of course, these numbers only tell us so much, right? How much do we really learn by saying that 7 of the 9 Supreme Court justices were appointed by Republicans, or 60% of federal appellate judges were appointed by Republicans? We can learn a little more, of course, if we spend some time looking at who these people actually are. You all probably know at least a little bit about John Roberts and Samuel Alito. If you looked at Bush's appellate appointments, you'd find a lot of others with good conservative bona fides, like Roberts and Alito. People like Brett Kavanaugh, William Pryor, Jeffrey Sutton, Priscilla Owen, Janice Rogers Brown, Deborah Cook, Michael McConnell, Jay Bybee, and the like. I could go on. These aren't household names. You may not have heard of very many of them, but you can look them up if you want. And if you're, I would venture to say that if you're a social conservative or a business conservative or a foreign policy conservative, you will find some names on that list that make you happy, right? Bush has appointed a large number of solidly conservative men and women to the federal courts. But again, what does that tell us? What's really important is not who these people are, but what they do with their judicial power, right? So what do they do with their judicial power? These men and women have lifetime appointments, which means that at least in terms of, at least chronologically, one place in which we might want to look for Bush's long-term legacy, right, is on the federal courts, because his appointments will long outlive his own tenure in the White House. And because they have lifetime appointments, it is, of course, far too early to assess their legal legacy. It's clear that they've handed a number of legal victories to conservatives already, but again, it's too early to assess the long-term legacy, and it is also, as I've said, hard to summarize the record quickly. So here's what I thought I'd do, which I think I can do in the time I have left. Focusing on the Supreme Court level, where again, Bush has added John Roberts and Samuel Alito to the court. Focusing on the Supreme Court since those appointees joined the court, right? So focusing on the Roberts Supreme Court, which is in significant part a construction of President Bush. What can we say about the impact on the law that President Bush has had? And I think it's fair to say, and I'm going to do this kind of quickly, but I think it's fair to say that at least the basic storyline that I'm going to emphasize would also be similar, right, if you looked at the federal judiciary as a whole, right? And that basic storyline is that the president has clearly moved the courts rightward, right? John Roberts and Samuel Alito have clearly moved the Supreme Court rightward, but they have not yet established firm, reliable, conservative control of the third branch of government. Consider one example. The case of Hudson versus Michigan in 2006. This case involved a police search of a private home in which the officers failed to follow the so-called knock and announce rule. They had a warrant to search Mr. Hudson's home for drugs, but they did not knock on the door, announce their presence, and wait a reasonable time before entering, as the court has held the Fourth Amendment requires. Now, when the case was first argued in 2005, Roberts had already joined the bench, but Alito had not yet been confirmed, so O'Connor was still on the court. Justice Breyer drafted a majority opinion holding that the evidence was illegally obtained and hence must be excluded from trial. Justice Scalia drafted a dissent which insisted that the Fourth Amendment exclusionary rule, the rule that illegally seized evidence must be excluded from trial, that rule does not apply to violations of the knock and announce rule, and Scalia said may no longer be necessary at all, the exclusionary rule. Alito's confirmation went through before the court decided the case. O'Connor stepped down. The other 8 justices were divided 4-4. Following their standard procedure, they ordered that the case be re-argued so the new justice, Samuel Alito, could participate. Alito voted the other way, right? He reversed O'Connor's vote. O'Connor had voted with Breyer. Alito votes with Scalia, switches the outcome, turning Scalia's dissent into a majority. Now, this opinion would have marked a sea change in the law, reversing a landmark Warren Court precedent from the early 60s. Now remember, Scalia wrote, not just on the facts of this particular case, but in general, the Fourth Amendment exclusionary rule may no longer be necessary, we should get rid of it. That would have marked a sea change in the law, except Justice Kennedy wouldn't sign the opinion. Justice Kennedy voted with his fellow conservatives. He agreed that the evidence could be introduced in this particular case, but in a separate concurring opinion, he wrote that the continued operation of the exclusionary rule, as settled and defined by our precedents, is not in doubt. Since Kennedy's vote was necessary to the 5-justice majority, his limiting construction was controlling. So to sort of sum up the lesson of this example, Bush's replacement of, now Roberts replacing Rehnquist made essentially no difference in this regard, right? But his replacement of O'Connor with Alito directly reversed the outcome in the case. This is clear, right? Directly reversed the outcome in the case and nearly produced a sweeping conservative change in constitutional law. Nearly, but not quite, right? Kennedy wouldn't go along with it. The same general pattern has characterized much of what the Roberts Court has done in its first 3 terms, now, first 3.5 terms now.